one of the adult services librarians at Piscataway Public Library, and we are very pleased to welcome Kenneth Vercammen, local Edison attorney and author of the ABA's Wills and, I'm sorry, I lost my page. Sorry,
Wills and Estates book for the American Bar Association.
Yeah,
You're
beg your
good.
pardon.
All right.
Um,
All right.
so the way that this evening is going to go, we are going to have Mr. Vercammen present, and then he will answer some questions. People thankfully posted some advanced questions when you registered, so we will answer some of those questions. And then we will also have a guest this evening, a financial planner from New York Life Securities, Dan Fabrizio, who will answer questions about financial planning and mistakes one should avoid while doing that, especially in light of COVID-19. Okay. Thank you, Ken. Welcome.
Okay. Very good. Thank you, Joy. Thank you, Piscataway Library. Well, it's been a weird past year because we used to be in front of crowds of people, and now we're talking into screens. But on the other hand, no one has to drive in the rain, drive in the snow. But there's been many changes that we didn't anticipate a year and a half ago. But one thing's remained the same. I'd say bad things happen when you do no planning. Bad things happen when you don't have a valid will, a valid power of attorney, a valid living will. So, for example, sometimes people will say, why do I need to have a will? I'm married. Doesn't everything go to my spouse? It goes, well, maybe, maybe not, but that's not doing planning. That's like not having life insurance when you're young and have kids because you don't plan on dying. Things happen. So, for example, if someone does not have a will, or the will was not found to be valid because it was improperly prepared or improperly signed and thus not admissible to probate, the process to distribute assets becomes much, much more complicated. So if there's no will, it would require all the children to select and agree upon someone in the family to be an administrator. Then all the children would have to sign a renunciation affidavit in front of a notary. If all the children don't sign a renunciation affidavit in front of the notary and have it filed for a fee with the surrogate, then a complaint or to show cause will have to be filed in the Superior Court. The cost is over $3,000. Well, the cost of doing a will, someone's looking at $400, $500. That's certainly less than $3,000 and less aggravation. Number two, if there's no will or the will isn't done right, then the person who becomes the administrator has to take out what's called an insurance bond or surety bond. So another additional $1,000 or whatever fee, and there's additional legal cost. Three, if someone doesn't do these things ahead of time, state law determines who gets the assets, not you. And more people are saying, listen, do I have to provide equally, or can I instead, distribute as I do? And he goes, yeah, it's your right. So during the program, more people are saying, listen, I'm going to give it to my grandkids rather than my own kids. Why should my son, Dr. Brendan the dentist, have a bigger boat? I'd rather have it go down the road to grandkids. Or sometimes you got kids that don't spend time with their parents or grandparents. So you want to be able to have the document done and determine who's going to get your assets. If someone has minor children, think about, hey, if something happened to both parents, who would you trust to raise kids? Who don't you want? Because sometimes the easier thing is, who don't you want to be the guardian for kids? And instead, if there's no will, a stranger in New Brunswick, the judge determines that, and you reduce the opportunity to cut down on expenses. But most importantly, by not doing proper planning, I'd say you're creating problems and aggravation amongst the family, usually fights, lawsuits, etc. So when loved ones are grieving, dealing with the passing of a family member, they shouldn't be overwhelmed with financial concerns, estate problems, etc. So believe it or not, one of the things that COVID did, it made everything easier to have the documents done, because prior to this, we used to require everyone to come into our office by appointment, during business hours between 10 o'clock and 4 o'clock, take a pen and write out everything in their own handwriting. And now, back last January, goes, you know what? Let's start doing something new. Let's start doing something better. Let's email the questionnaire. This way, people can fill everything out at their home. They can save it as a Word document, not a PDF. They can email it to us, and without people even coming in, I can then call everyone up and say, okay, here's what I suggest based upon your facts and circumstances. And and New Jersey, by the way, did away with the New Jersey estate tax. So, people are saying, what? You didn't list my assets in a will. He goes, I don't need to know your assets, really, because, let's say, unless you have more than $11.7 million, there is no estate tax. That's the amount for federal. So, not too many people I know have more than $11.7 million. And for people that come from, I'll call it the, regular family, together. I said, do you want to disinherit your wife? They usually say no. Do you want to disinherit any of your kids? No. Do you want to disinherit any of your grandkids? No. Okay. I know what people need, sometimes better than what they have, because I've been doing this for a living for 35 years. And when I needed knee surgery years ago, I didn't ask the doctor a lot of questions on, how exactly it was happening. I goes, doctor, you've done this before, and do you think it'll be successful? So, what else has changed with COVID? Well, again, people can pay online through credit card, PayPal for their attorneys, and probably the easier thing is that what happened last March and April. The whole state closed down, except for the UPS stores. So people were able to go to the UPS stores on the weekends after 5 o'clock and get their documents signed with a spouse and another friend as a witness, and they didn't have to drive to the attorney's office and take half a day off of work, or coming from the city. So it was made easier. But part of what we also say to people is it's still a call to action, because what was also happening is, like, people are saying, listen, I need to get a will or power of attorney for mom, dad, or Uncle Joe because they're in a hospital. I goes, well, by this time it's typically too late. And what happened? Even now, a lot of the nursing homes, a lot of the hospitals, no one can come in. They're closed to the public. So the whole idea is getting your things done now, and having things done right. I mean, if someone knows they're going on vacation, you don't decide on a Friday where you're going to go and how much you're going to spend. You plan ahead of time. So we've tried to make and so let's now talk about things that will go into the will. Well, the attorney sends someone a questionnaire, and basically someone types in their name, a spouse's name, who's going to be executor one, who's going to be executor number two. We never recommend joint executors. Let's say there's a reason why there's not two captains of the ship and two steering wheels. There should be one person as number one as number two. I've seen a lot of problems where people have joints, and even if they could be identical twins living together, best of friends, but you're creating twice as much work, because that means that two people have to sign the the paperwork for the surrogate. Two people have to sign a listing for the realtor to sell the house. Two people have to sign the contract for the sale. Two people have to sign the addendum to the contract. Two people have to sign every single check, every single document. Why create more work? On the other hand, we've had cases where there's two people that they couldn't agree upon what color the sky was. Brother number one says the sky's blue, and the other one says, no, it's gray. You're stupid. You've always been stupid. They're yelling at each other in court and fighting over couches. So the better thing to do is there's an executor one and an executor two, and keep in mind who should be the executor. Well, It should be someone that can, you know, kind of do the job and you know, when COVID's over, we can get around. You know, that our rule of thumb is, can they drive to the surrogate's office? Can they park on the third floor or the fourth floor, take the elevator, then walk up the hill and go to the surrogate's office? Let's see, because the idea is, if someone can't drive, if someone can't walk up a flight of steps, well, it should be someone that is more mobile. I'm not anti senior. I'm not anti disabled person, but we have to be practical. We want to try to make it as easy as possible. And if someone is like 89 years old and they're partly blind and can't drive, they're not the best choice to be the executor of the will. Now, we do most of the things remote, but I always talk to everyone. Again, I call everyone from the car. I call everyone from the office, and we do ask a few questions in the interview form. Do you own any real estate? Where is it at? Approximate value. Then we ask questions. Okay, other assets, ballpark, approximately how much? Don't need to know account numbers. Don't need to know details, because the real thing is, assets are not listed in the will unless someone knows the exact day they're going to die and what they're going to own on that day. Now, there are certain assets, though, that don't pass under the will. So examples of that are, if a house is owned husband and wife, say, well, that's called tenants by the entirety, automatically goes to the surviving spouse. Sometimes houses are owned joint tenancy. Sometimes people in a relationship but not married own it joint tenancy. It goes to the survivor. Sometimes a child and a parent may buy a house where it's going to go to survivor. So a will doesn't change that. Bank accounts that are POD, payable upon death, right of survivorship, those automatically go to the survivor. The will cannot change that. Now there's certain assets that pass by way of contract. And examples of that are IRA, 401k, life insurance, annuity, a pension vehicle, anything that has a direct beneficiary. The will cannot change that. So I typically recommend that when people are doing their estate planning, that they get a printout that specifically sets forth who is the beneficiary of that account, and then they put it in the folder with their will documents after they sign it. This way, you're making life as easy as possible for the executor, especially if the executor is not someone who lives with you. And why seeing the beneficiary in writing is important? Well, let's see, never assume. I was married for a decade, and I found out one of my life insurance policies still had my dad. 10 years. I assumed everything was changed over. We missed one. Well, now, I know my dad would have done the right thing, but why create more work? So, now, typically, when you're doing your planning with the attorney, you're setting forth, hey, who's going to get your stuff? But keep in mind, if that person passes, who would get that person's share? Let's see. And more, I mentioned, people are not, leaving it outright to everyone equally. They don't have to, because some kids or grandkids need it more than others. Some people are saying, listen, I'd rather put it towards my grandkids' education, so they can go to a better school, as opposed to leaving it to one of my own kids that would just buy luxury items and wouldn't use it on getting the grandkids the best education. On the other hand, sometimes people, someone recently asked me, do I have to treat all my kids equally? And I goes, no, that's your right. You decide. It's your right. You're right. You don't have to leave anyone anything. What do you have in mind? And she goes, well, one of my kids, we don't hear from much, lives on the West Coast. So I said, well, I'll ask you a question. Christmas, did he get a card or a call? She goes, no. On your birthday, did he get a card or a call? No. On Mother's Day, did he get a card or a call? No. Well, why should you leave that person anything? On the other hand, sometimes we set up trust within wills, so that you could have a child that is they have like issues. You know, they could have substance abuse issues, financial issues, and we just don't want to have them plopped with getting $200,000. I handled a litigation case in Somerset County, and the lady had set up a trust, and the monies for one of the kids was to be used for that person's support, but so that the person had, their apartment was paid for, car insurance was paid for, because the person had alcohol problems. And there was a motion by his ex-wife to invade the trust to compel it to pay over for alimony, etc. But the judge agreed with me. The reason why we set up sometimes these spendthrift trusts within the will is so that it's protected from taxes and from ex-spouses and from creditors, etc. Because hey, if you give an alcoholic $100, they'll buy $100 worth of booze. You give someone $2,000, they'll spend $100 on booze and give away the rest. So the whole idea is to try to make it as easy as possible. Now, sometimes people don't have any children. He goes, well, you're the more important people that should have it, because who don't you want to get it, and who do you think could benefit best by someone's money? And people sometimes say, you know what, let's see, I'd like to give some money towards my church, towards my charity. I left money towards my college's cross country team, University of Scranton. I left money towards the St. Thomas Bishop Art track team, because they not a huge amount, but something towards St. Francis Grammar School's track program. So the idea is that you can put these kind of things in the will. So specific amounts are called specific bequests. I'd say, but there has to be in writing. So on Mother's Day, someone could be recorded saying, "Hey, I want all my jewelry to go to my granddaughter." But not only does the executor not have to follow that, the executor is not allowed to follow that, because the executor has to follow what's in the four corners of the will. Some ladies sometimes say, listen, I want the jewelry to go to my daughter, my granddaughter, because they know that if their son's the executor, he'll bring it to Cash for Gold and say, what do you give me for this junk? I've had men who have, they have hunting rifles or, things like that, and they give it towards someone that has a firearms permit, or they might have their baseball card collection or coin collection, and it makes them feel good that they left their baseball cards to someone. Now that person could leave it to, have things that people think are valuable are not. Collectibles are only collectibles when you spend the money for them to collect them yourself. All right, now we've mentioned specific bequests. Sometimes people have the reverse specific bequest, meaning I leave nothing to and name a person. And again, it's someone's call what they want to do. We don't leave them $1. We don't say a reason why. But if the person passes, they do need to be, anyone who would inherit under the will, without the will, it just have to be served a written notice of probate. But that's part of our probate thing. Right now we're talking about wills. Now you do want a clause to protect minors, or protect 24-year-olds, because listen, we all know when we were 23 years old, and if we would have got a big chunk of money, would we have invested it wisely? No. The age of majority in New Jersey is 19, and I'm pretty sure no 19-year-old invests money wisely. So typically when someone has minors, we have a clause that says they get some money when they're 22, some money when they're 25, the balance when they're 30, but the executor trustee can distribute as much money as is needed for that person's support, maintenance, care, etc. But that's important, because otherwise, if there's not there, they get the money when they turn 18. And not only do 18-year-olds not spend money wisely, but they get influenced by what we call the other. So if someone was going to be inheriting money when they turn 18, if it's a dude, all the girls would be their new friend and try to get the guy to buy them nice jewelry. For the girls, their boyfriend would say, oh, you should rent a house down at Seaside for the summer. You have money, this, etc. So the idea is the monies that we have worked so hard for, we don't want to give it to a kid or a grandkid that's just going to run off and blow it on stupid stuff, or be threatened to give over money. Because listen, what do 19-year-olds do? They try to get someone to buy them beer and go down to Seaside. Now, if someone has minor children, there's a clause that says who's going to be the trustee. Think of the trustee as the person who holds the money. The guardian is the one who holds the children. So I ask my clients, sometimes they can't decide right away. He goes, okay, who do you trust to watch your kids for the next 2 weeks? And then I ask them, who don't you want? Well, there's not really that many choices. No, it's a tough call, but no, it's not a tough call. Now, I'd say they're used old wills. I'd say used to have to find the witnesses. So there was a law called the self-proving will statute. So under the old method, the person signed, two witnesses signed, but then typically you'd have to locate one of the two witnesses to sign an affidavit or go to the surrogate's office to say, yes, that's my signature and I witnessed the person sign. Well, I remember in one case, they said they wouldn't sign unless they got $500 out of the family. $500 for signing a piece of paper. So the new statute is self-proving. That's where someone signs, the two witnesses sign, the attorney or notary signs, and then we have the self-proving attestation, affidavit clause to indicate the person signs again, the two witnesses sign again, the attorney or notary signs again. That way the witnesses don't have to be located after the fact. And the good thing in a way is that it saves the people money. And I'm pretty sure that old documents that were done years ago don't have that. I know that these cheap things that people try to find online are not usually self-proving. They don't comply with the Uniform Probate Code, and then the people think they're saving money, but it's costing them more in the long run. What else do we? And typically the interview format asks, hey, what questions do you have? I'd say sometimes people ask me, what if I move? Well, your will done in New Jersey is valid in any other state. I'd say, how often do I need to change my will? I'd say a will that's done now is still good in 30 years, but the question different is good, or does it still contain what you want? But if you have an older will, look to see, is the person who you picked as your executor still able to do the job? My grandfather was a smart guy, but when he was 95 years old, he didn't run up the 5 flights of steps to go to the 5th floor of his place in the Bronx, but he was the executor of his cousin's will because it was never updated. Now, logistically, due to COVID, what we do is we email out a Word document of the will, power of attorney, living will to everyone with instructions on how to sign. And the reason why we send people a Word document is after they receive it, sometimes they say, you know what, I want to switch around who these two people are. He goes, okay, no problem, you can do that. But I tell people, do not change the legal part of it because then you're screwing it up. I mean, if you have medical issues, don't try to do your own surgery, and don't try to do your own electrical work. Let a professional do that. So, in the will, clauses are: number 1, debts and taxes paid; 2, distribution to spouse. Sometimes we have a trust set up for a spouse. It's very common in second marriage situations, but sometimes with older people, instead of leaving the money outright to them, if money is left to the spouse in the will in a spousal trust, then that is protected from Medicaid. It's protected from creditors. Distribution to children or grandchildren. Sometimes there's a trust within the will. Let's say you're putting down who's executor 1, who's executor 2, a clause that says no bond required, and after the documents are signed, then I recommend that the people now only the original will can be admitted to probate. Let's say a photocopy of the will cannot be admitted to probate by the surrogate. Think of the surrogate as a fancy name for the will clerk. Let's say they need the original will, an original death certificate. They need their surrogate information sheet filled out, and a check for maybe $150. Let's see, no original will, then there has to be a formal complaint, order show cause, and everyone that would have inherited if there's no will has to be served, and then there has to be a hearing in front of a judge. So, now why do people sometimes scan their wills? Well, the only reason they scan the wills is so that they can forward it to their kids and say, "Listen, this is what we signed, and this is who the executor is, and if you have any problems, come to me. Don't bother your brother down the road." All right. But the important thing is, I tell everyone, if you don't know where your original will is, get a new one done. Say again, a rule of thumb is that if you can't find it in 40 hours, don't cheap out. Go get the new one done. Now, let's now touch upon trusts. Separate trust, revocable trust, living trust, etc. Let's see. Periodically, people will ask us, my mother-in-law used to always say, I want to come in and get a trust done. And I said, "Were you watching Susie Orman?" And she said, "Oh, yes." I go, Susie Orman is exactly right, having these revocable trusts done. If you live in New York, California, Florida, probate, difficult states. New Jersey is the probate easiest state in the country. So when someone says they want to have a trust, it goes, why do you think you need to have a trust done? Some people says, I want to avoid probate. Well, probate costs $150. Let's say they say to save taxes. A living trust doesn't save taxes. It's not. The living trust salesperson says, it's a private document and doesn't have to be admitted to probate. But listen, unless someone's leaving their money to the Ku Klux Klan or Crazy Club, what do you care if everyone knows who's getting your stuff? It's usually no big secret who's getting your stuff. I'd say, but they're one of the few benefits of the trust was the people that had trusts when the surrogate's office closed to the public and nothing was being probated for weeks and weeks and weeks last spring. If there's a trust, that can be, as soon as someone dies, hey, you're good to go. Now there's a different, but a living trust is revocable. It does not protect any money from creditors. It doesn't protect it from Medicaid because you have the control. There is a thing that's called the irrevocable trust. So that's common for in cases of people want to protect their assets in the event they have to go into a nursing home. But so that means that the assets are no longer owned by you; they're owned by the trust. You're not the primary trustee. Someone else got to be the trustee. You can't close the trust. And so a lot of times there's pros and cons, but I do tell people that listen, having trust done, they're usually spending like $3-4 grand a piece, and they're retitling assets. And the other thing is that if there's a mortgage, you want to get permission from the mortgage company because the mortgage always has a clause that says you can't transfer ownership to another entity without their approval. So that's a little bit on living trusts. Yeah, they avoid probate, and someone has to explain to me why they want it. Now, if someone has a condo in Florida, he goes, definitely put that condo into a trust in the state of Florida. That's for someone's benefit. Okay, so after you sign your what we also typically, as mentioned, we email out the documents. We tell everyone, print them out and read them. Don't read them on your iPad. Don't read them on your iPhone because you don't read them thoroughly. Print them out and make sure it contains what you want. We do a self-proving will. We include a clause that says No bond is required, and that way it's as accurate as possible. Now, and by the way, I always tell anyone that attends any of our programs, if you attend our program, we typically charge a $200 consult fee. But if they attend our program, we wait and they come and see it, they contact us within 30 days. We don't charge a $200 consult fee. Okay, the next document we're going to talk about is a power of attorney. Your will takes care of your assets in the event that you die. What a power of attorney is, it's a document where you're giving the power to spouse, family member, or someone you trust to make sure that if you became incapacitated or disabled, that your bills can be paid and that they can act on your behalf legally. And for a lot of people, the power of attorney is more important than the will. Let's see. Just because someone's married, it doesn't give the spouse the power to transfer assets and sell a house. And the important thing is, we often get calls on a Friday afternoon. I need to get power of attorney over mom, dad, or Uncle Joe. He goes, well, unfortunately, you can't get power over anyone. Let's see. They have to affirmatively give it to you. They have to say, yes, this is what I want. I want to give power of attorney to someone else, and they have to be physically capable of talking and signing. If they can't do that, then there's no power of attorney, and someone has to go through an expensive and complicated guardianship proceeding. And again, who wants to have to go through this complicated and expensive guardianship proceeding? It's guardianship proceedings are very sad, expensive, and lengthy. So, in the power of attorney, you're giving the power to someone to make sure that your bills are paid, that your assets are, kind of protected, because you're giving the power to someone you trust. Now, the power of attorney is either effective right away or only upon disability. If it's effective right away, that's called a durable power of attorney, and it stays in effect durable even if someone becomes incapacitated. Effective only upon disability. Most people don't pick that, but it's only effective if someone becomes disabled within the statutory definition of disability. Now, we had a client, he says, Kenny, you're using legal jargon on me. He goes, I'm a carpenter. Please explain to me in carpenter language, not springing and durable and etc. He goes, okay, that's it. Joe, that's easy. Okay. Let's see. If your power of attorney is effective right away, your son can steal all your assets right away. If it's effective only upon disability, your son has to get a note from a doctor before stealing your assets. Knowing that, do you trust your son? He goes, oh, I trust my son with my life. I goes, well, good. Then make it effective right away. That's what most people do, because if it's effective only upon disability, then you got to go and prove, get a note from a doctor, and then you got to go and prove to a bank that the person, the note is good, that the person is disabled, and that they're not dead. So we recommend that it be effective right away. Now, after the power of attorney is signed, you need a witness who is not the agent, not the spouse, and it's signed in front of the attorney or notary plus the other witness. I do recommend that document be scanned, and then you want to forward it to yourself, agent 1, agent 2, your kids if you deem that appropriate. Plus, you want to forward it to your financial advisors. You want to forward it to your bank, any place you have money, your accountant. Therefore, they have it on their record. So in the event that it has to be acted upon, then again, it's already in clear writing what you wanted. And part of doing planning is planning to make things as easy as possible. Because here is something also that is important. Let's say some of the banks used to give people a hard time, and they'd say, "Oh, it wasn't done on our Wells Fargo form, so we need to have it done on our Wells Fargo form or whatever bank." And so, eventually, the New Jersey legislature came up with a law to say, listen, if it makes reference to New Jersey statute, and the bank does business in New Jersey, the bank has to honor it. But it has to make reference to the New Jersey statute, Section 2 of PL 1991, C 95, C 46:2B-11. And I'm pretty sure the cheap things or free things you find online aren't going to say that. So again, let's say have it done right, so that therefore it's valid. Now, let's see, I mentioned a will is valid now, it's valid 10 years from now, 20 years from now, 30 years from now. And no surrogate can say, well, it's old. However, I do recommend people re-sign a new power of attorney every 5 years. This way you avoid the issue of a bank giving you a hard time or a financial institution. I do recommend if someone moves, or your agent moves, the kid or you've picked, if they move, have a new one signed, because the problem is, someone has their daughter as their agent. Then the person breaks their leg. They go to the bank. The bank goes, "Who are you?" I'm Joe, Skuznik's daughter. He goes, "Well, you're a different. The person on this document has a different name and a different address." And the person goes, "Well, I got divorced, or I got married, and I'm living here now." And the no. We're not going to honor it. So the idea is, you do the documents and you put it, with your, served copy of the professional. The last legal document I'm going to talk about is the Living Will Advance Directive, durable power of attorney for health care. So think of the Terry Schiavo case, the Cameron and Quinlan case. Someone's in a coma, irreversible condition, they're in a hospital. Well, this document is not really for you, so your family doesn't have to go through the trauma of having to make that call. Let's say, because it's where you can't talk. So the idea is that, say you're giving instructions to hospitals and doctors that if there's no coming back, there's no getting out of the bed, no opening eyes again, what you would want. And I remember one time a doctor where someone did not have a living will asking me what should be done. Should we pull the plug? And I remember saying to Dr. Geez, doctor, I feel bad. I mean, you know what the right decision is for someone who's 92 years old that's never going to open their eyes again or walk the planet. And, but the idea is that you feel bad saying yes in that person's life today. That's why you want to have a living will, so that the decision's already made, and you can just say, doctor, this is what they picked, and respect their wishes. So in the Living Will Advance Directive, let's say we took language from the actual medical societies format. Therefore, doctors can be familiar with it. But the good thing is that, so they talk about fluids and nutrition, feeding tubes, etc. Let's say, to be withheld if someone's in a coma or provided. Now, some people got scared away, so you tell me that, if I had a heart attack, that they wouldn't revive me or do anything and just leave me on the floor of shop. Right? He goes, no, the hospitals and the paramedics do what is appropriate for someone brought into the emergency room. But we're talking about down the road, someone's on their last stages of a terminal illness, or they have a stroke and they're in a coma and there's no coming back and they're brain dead. Well, okay. You're giving those instructions. So, fluids and nutrition is provided or withheld. Then there's the next section deals with artificial, and probably 85% of the people nowadays say, "Listen, there's no hope for me. Let's end it all." Okay. Now, the next section, the Living Will Advance Directive, life-sustaining, medical treatment machines, and 99% of people say, "No, don't do anything. I don't want, pull the plug." Let's see. I used to say years ago, if I can't run every day, I want to be put down like they do the racehorses. And then the first time I was on crutches and I couldn't run, he goes, wait, I don't want to be put down yet. Keep me around. Okay? So let's and now there's a section also that says organ donation yes or organ donation no. And I always recommend, listen, if you're gone and you can help someone, then say yes. Something interesting is I went to a seminar by the NJ Sharing Network, and they're the official organ donor entity in New Jersey. I said, what's the maximum age to be an organ donor? And they said there is no maximum age. I goes, well, what's good on an 85-year-old guy? And they go, skin and corn. He goes, wow, I never thought about that. If I was burned in a fire, I'd rather have an old guy's skin than what got burned off me. Okay, real fast, we're going to talk now about probate. Now, probate in New Jersey, let's say it used to be I would tell someone, okay, if someone came into my office, like someone so died, it goes, okay, do you have the original will and a death? Yes. It goes, leave my office now, drive to Middlesex County Surrogate. It's 7 miles from here, and you'll be back in 45 minutes. Someone's in Monmouth County. He goes, okay, go to the Freehold Surrogate. It's 19 miles from here. Come back in an hour, and they'd be back in an hour. But the surrogate's offices, for the most part, are closed to the public. So we have to fill out forms. We have to forward them to the surrogate's office with a copy of the will, copy of the death certificate, the form filled out, and then they email. Some surrogate's offices email to us, others mail to us. Then we have to sign all these different forms, in front of the clients, and then we got to forward to the surrogate the original will, death certificate, check for $150. All these signed, notarized forms that we have, we send it by certified mailers. We can't even drive to the surrogate's office and put it in a drop box outside because they say close to the public, close to the public. Now, there's a handful of questions that I'm going to touch upon real fast, and then I'm going to have my financial planner, colleague, come in. So just bear with me because I'm trying to do as much tech stuff as possible. Okay, so number one, can a doctor serve as a medical proxy? No, the doctor cannot. Attorneys don't. It's usually a family member or someone you trust. Let's say there's only been rare times where I have even been an executive where someone says, "Kenny, listen, I'm 89 years old. My wife is 80. It's going to charities. We trust you." Okay, fine. I'll do it then. Let's see, who did you give your completed documents to? Everyone. Let's say someone mentioned a gifted deed. The problem with just gifting things away is that if there's a falling out between the two, then they can kick you out. Sometimes that's a rare instance where rather than just gifting it outright, maybe you want to put it into a trust where they're getting it, but it's there. A will that was done in 1995 is still valid, but you got to look, okay, do you still want those people as executors, or are your kids grown up from 1995? Is a notarized letter stating bequest given to children okay? No, because that can't be admitted to probate by the surrogate, and that sometimes causes fights. Let's say IRA retirement accounts. Who's ever listed, that's who gets it. Now, currently, there's a step up in basis for certain assets if someone dies. Let's say someone bought a house in 1990. They bought it for $30,000, and now it's worth $430,000. Well, if someone dies, there's a step up in basis, so the family doesn't have to pay capital gains. However, if you just transfer it to them, they get the carryover basis. So we're waiting to see what the new president's going to do with that. Someone mentioned, let's say, if someone's divorced, their spouse is written out of the will, but it's still important to get new documents done because there's old documents that you've given the power to a spouse to do stuff, and you really trust that spouse can walk into a bank and illegally withdraw your money. Probably not. So I mentioned if someone's name changes, if they move, get a new power of attorney, new living will. Can a lawyer serve as the power of attorney? We don't do that because it should be a family member. the process. What's the process on starting a will? I mentioned that we email out the will questionnaire to people, and we don't need to know a lot about someone's assets because they are typically, leaving it to the people that they like. I'd say quick claim deeds to minors. Don't do it. I was in probate court one time, and it wasn't my case, but someone had signed over their house to one of their kids. The daughter was living with her, and then she gets remarried. The new husband's in the house, and the new husband finally says to his wife, "Hey, you got to get rid of your mom. She's driving me crazy. She's a kook." And so the daughter goes, "Okay, mom, you got to get out." "But this is my house." "Not anymore." And the judge said, "Listen, this is a horrible case, but the law is the law. The gift was made." Someone mentioned, should I still have a will even if our bank accounts have survivor beneficiaries? Yes, because there's always assets that someone has that does not have a direct beneficiary. And also someone should always have a power of attorney, because a will is only of assets after you pass away. Um, Other quick questions. I've discussed estate planning. Doing an LLC. An LLC does not protect as well as someone thinks it is, because let's say if someone owned a house, rental house, and it's owned by the LLC. Yeah, if someone got hurt, the LLC protects you from liability, but probably still going to be a defendant, because they're going to say you did the repairs negligently. So, we typically recommend, someone owns like investment properties, have good insurance. Computer software, I tell people, don't cheap out. Don't do your own electrical work. Don't think you can watch a YouTube video. People used to change their own oil in cars. It's like someone says, "I'm not going to go to a doctor. I don't want to pay the deductible. I'm going to go to WebMD and figure out what I have." Let's say, having wills done, the attorney is going to charge you, $400 or $500 each. It is very good investment to have things done. Now, if someone gets when someone's getting married for a second time, they'll call me up and goes, "I want to get a new document done." I goes, "Listen, why don't you hold off and see how things pan out?" "Oh, we've been together for 3 or 4 years." It goes, "Well, listen, if you want to put them on some of your accounts, go do that. But let's listen. I always say I love making money, but let's wait and see how this marriage things pans out. We don't want to have 20-year-olds get money." Okay, so that is like I've touched upon wills, powers of attorney, living wills, a little bit about the surrogate's office. We don't have a lot of time to cover everything on the planet. So, I always tell people, hey, down the road, let's say, speak to, consult with a professional to have things done right. And with that, what I'm going to do now is ask that the library now bring in Dan Fabrizio to talk about some of the common financial planning mistakes that he's seen through COVID.
Good evening. Joy, is there any more questions for Ken, or are we good to go?
Well, there's a few more in the chat. Did you want to?
Let Dan start his